Hello, and welcome to the final edition of Nelson Mullins' 2020 Education Law Webinar Series. We're glad you could join us today. My name is Dan Cohen, and I'm a partner on Nelson Mullins' Education Law team. Nelson Mullins is an AmLaw 100 firm with about 800 attorneys and policy advisors across 25 offices in 11 states plus Washington, D.C. Among other practices, we have a dedicated team of attorneys focused on serving all legal needs of education institutions, including in the areas of labor and employment, healthcare and issues affecting academic medical programs, construction and real estate, intellectual property, privacy and information security, and unique issues affecting education institutions like student and faculty discipline, sexual misconduct, and athletics. Each month, we host a free webinar addressing legal topics across these areas, and sometimes more frequently as issues arise. As this is our final installment of the 2020 webinar series, we invite you to please enter comments in the comment box to tell us what you'd like us to talk about in the 2021 calendar year. We are open and welcome your suggestions, and we look forward to hearing back from you. Today, Marquetta Bryan and Kathryn Ams will be talking about employment law in 2020, piloting through the pandemic puzzle. Colleges, universities, and K-12 school systems continue to be inundated with challenges arising from the COVID-19 pandemic. And today, Marquetta and Kathryn will talk about the legal landmines that should be considered when addressing requests for ADA accommodations during the pandemic, what some of the best practices are for employee performance management in a fully remote, partially remote, or face-to-face setting during the COVID-19 pandemic, how colleges, universities, and K-12 school systems balance competing considerations for public health disclosures in the midst of challenges such as those that we're facing today, as well as what employers should be doing to ensure compliance with the FFCRA, and how employers should prepare for the uncertainty of whether the relief of the FFCRA will be extended into 2021. Marquetta Bryan is a member of Nelson Mullins' education team in Atlanta. Marquetta focuses her practice on employment law and litigation, policy and governance, compliance, and investigations. Marquetta has over 17 years of experience representing exclusively employers, including K-12 clients, institutions of higher education, both public and private, and nonprofit entities, in discrimination matters, wrongful termination, harassment, and retaliation cases. Marquetta works closely with employers to develop best practices and legal strategies in managing employee relations that support mission and business objectives and efficiency in operations. Kathryn Ams is an associate on the education team at Nelson Mullins. She has almost 10 years of experience representing various school districts, charter schools, and private schools. In addition to her K-12 clients, Kathryn also works with institutions of higher education. She focuses her practice on employment law, regulatory compliance, and legal issues involving students with disabilities. And with that, I will turn it over to Kathryn and Marquetta.
Thank you. It was likely a day like this, probably exactly 1 year ago, where you were planning your winter travel, justifying unmet New Year's resolutions, and looking ahead to what you thought would be more clear and successful 2020 vision. It was in fact a day like this that you had no idea that 2020 would consist of spending several quarters of it in your homes, daily COVID-19 briefings, hundreds of accommodation requests in a short time span to telework. And here we find ourselves 1 year later in the third quarter of a pandemic we never imagined, still trying to navigate our way through it. Kathryn and I would like to help you do a bit of that today. So whether we're in the middle of a pandemic or not, employers always need to balance the overarching ideals of fulfilling productivity and operations objectives and the needs of their workforce, their employees. But let's admit, ending this third quarter of COVID-19, even the most seasoned human resources professionals are spending more time with employee leave and accommodation requests that are made because of COVID-19. So depending on where you are with your reopening and return of employees to a physical in-person workspace, the ebb and flow of your requests for accommodations at this time may either be steady, increasing, consistent, or ramping back up, particularly in light of the onset of cold and flu season and rising numbers of COVID cases. So we will try to cover a lot in this hour with you. As a refresher, Title I of the Americans with Disabilities Act, the ADA, applies to private employers with 15 or more employees and to state and local government employers, employment agencies, and labor unions. This is the section of the ADA that employees most often rely upon in bringing discrimination and failure to accommodate claims against employers. So while your favorite restaurants and businesses may still be closed due to the pandemic, employer responsibilities under the ADA have not been relaxed or suspended due to the pandemic. According to the EEOC, the ADA relates to COVID-19 in 3 essential ways. The ADA regulates employers' disability-related inquiries and medical examinations for all applicants and employees, even those who do not have ADA disabilities, and Kathryn will talk more about that later. The ADA prohibits covered employers from excluding individuals with disabilities from the workplace for health or safety reasons unless they pose a direct threat. And the ADA requires reasonable accommodations for individuals with disabilities absent an undue hardship. And so we'll definitely talk more about that undue hardship during a pandemic. So for the past year, you've probably paid most of your attention to this accommodation part of the ADA. But we remind you that we anticipate that employees will raise both failure to accommodate and general discrimination claims related to the pandemic now and post COVID-19, whenever and whatever that looks like. So consequently, employers face a host of compliance issues in navigating leave and accommodation issues. So considering the limited time that we have together, because we know that sometimes evaluating an accommodation request can take an hour, we will try to hit some of those things that we see as particularly relevant during the season. Kathryn, do you want to add anything before I continue?
No, I think that, there are, as you mentioned, Marquetta, there are so many different accommodations we could touch on today, but what we're really trying to do is walk you through just a couple of samples of things that really would be relevant to what you're dealing with, and just show you the level of analysis that we go through with our clients when we're trying to look at different ADA accommodations, particularly during this global pandemic.
Absolutely, thank you. So I'd like to start today just by talking about something so basic and simple that's become a part of our new normal, the face mask. It's a very common piece of PPE, personal protective equipment, and that will lead off our substantive discussion today. I have no knowledge of when and if wearing a face mask may end, even with all the discussions related to vaccines. And while face masks are not controversial per se, they really do fall on both ends of the spectrum related to an employer's need and desire to protect the public and its employees, and employees and other stakeholders requesting or asserting that they be allowed to refrain from wearing masks. In an October 2020 decision out of the District Court for the Western District of Pennsylvania, the case is Pletcher versus Giant Eagle, and if you're taking notes, that case number out of the District Court for the Western District of Pennsylvania is 220 CV 00754. In that case, the court denied a preliminary injunction, which would have been granted, would have required Giant Eagle to change its policy of requiring all customers to wear face masks or some other face covering inside of its stores. So while this is not binding precedent for Georgia, and it's not a case related to K-12 or higher education institutions, it's certainly instructive regarding the analysis the court undertook in evaluating the claims of the plaintiffs in that class action. In summary, over 50 plaintiffs in a class action claimed that Giant Eagle was in violation of Title III of the ADA by denying access to customers who claimed that they could not wear face masks due to their disabilities. So fact specific to this case is that the Pennsylvania Department of Health had issued an order that face masks were to be worn in public spaces and that those who could not wear face masks could instead wear a face shield. That plaintiff group claimed that the store's actions to exclude them from their stores because they were not wearing masks or a face shield constituted retaliation and coercion in violation of their rights under the ADA. Giant Eagle countered with all kinds of reasons that its modifications to its policy were unnecessary. For instance, people could shop with other types of face coverings, including face shields, and that they also had alternative means to provide the services that those customers were coming into the store to receive, such as curbside delivery, home delivery, and some other options. I remind you that the plaintiffs in this case brought this under Title III of the ADA as opposed to Title I, which we discussed earlier related to employee discrimination complaints. Title III allows individuals to assert access to public accommodations and requires that they have equal treatment. Title III does not apply to religious colleges and institutions, but can apply and does apply to private institutions. So I want to remind you that to prevail on a Title III claim, just as a refresher, a plaintiff must establish discrimination on the basis of disability. So this is very relevant to our analysis in the employment context. They also must establish the full and equal enjoyment of goods, services, and facilities, privileges, and advantages of the owner, accommodations, and operator. So there were a couple of things that the court considered in determining that this injunction should not be granted. The first is that the plaintiff did not present, and I quote, a colorable factual basis, and I end quote, showing that he had a disability preventing him from complying with the store's face covering policy that permitted customers to shop inside of its stores while wearing masks or full face shields. The court also found that the plaintiff did not challenge those safety reasons why the Pennsylvania Department of Health had issued orders requiring people to wear face coverings to mitigate the spread of COVID-19 in businesses like Giant Eagle and other public spaces. The court also determined that the plaintiff neither alleged nor presented any evidence that he was actually unable to wear a full face shield, which was the mask alternative due to a disability. Though the plaintiff had asserted that he had a mental health ailment and could not wear the mask without experiencing anxiety or difficulty breathing, the court found that that was not supported by the opinions of medical professionals and that his disabilities did not seem to prevent him from wearing a mask. Finally, the court found that the named plaintiff failed to show that his requested accommodation of being permitted to shop in that Giant Eagle store without a mask was either reasonable or necessary. So I'd like to pivot just a bit and discuss whether there are reasons for an employee to not be able to wear a face mask. And there are. In fact, the CDC states that a person who has trouble breathing, is unconscious, incapacitated, or just otherwise unable to remove a face mask without assistance should not wear a face mask. So who might those persons be? Well, those persons may be individuals with asthma, and I say may because this may not cover individuals that have a similar impairment or disability may not react to the same type of PPE the same or request the same accommodation. So individuals with asthma, chronic obstructive pulmonary disease, or any other respiratory disabilities may not be able to wear face masks because of difficulty in impaired breathing. But it's not just people with breathing impairments. People with certain mental impairments may also assert that they cannot wear a mask. For instance, somebody with post-traumatic stress disorder, anxiety, claustrophobia, may also feel afraid or terrified. So what we do know is there are several reasons, mental and physical impairments and disabilities that may prevent an employee from actually wearing a mask. And I'll just add, people with autism may also be sensitive to touch and texture. And so a covering on the mouth and nose may cause a sensory overload. So we know various reasons that employees may not be able to wear masks. As I stated, the analysis that the court conducted in this case is similar to that complex analysis that employers like you are conducting on a daily basis, which requires an untangling of the federal workplace laws, along with intermingling of prevalent public health and safety guidelines issued in response to the COVID-19 pandemic. So when an individual does request an accommodation or a modification at work for a reason related to COVID-19, an ADA-covered employer is expected to initiate the interactive process to gather information and establish whether the individual has the right to receive an accommodation for a disability-related reason. Engaging in that required process is one way for employers to untangle that web of those workplace requirements during this pandemic situation. My clients have often heard me say to go all the way to the end of the rabbit hole or close every possible loop on requests for accommodations, because even seasoned professionals may view things differently, and these are often the source of litigation. So notwithstanding, for the most part, the interactive process looked the same as it did BC or before COVID, or for non-COVID related requests. Recognize the accommodation, request, gather information, explore, choose, implement, and monitor accommodations. One difference, however, that the pandemic presents is the need to pay greater attention to who is actually making the accommodation request under the ADA to even know if it applies. For example, many people are requesting to work from home as an accommodation to take leave and avoid contact with others for various reasons. These requests are not only being made by people with disabilities, however, but also individuals without disabilities, pregnant employees, older employees, and caregivers of individuals with disabilities for young children. However, for the ADA to apply, the individual requesting an accommodation must be doing so for their own disability-related reason, as the ADA does not cover individuals without disabilities. So if the interactive process yields information that the requester is a qualified person with a disability and the request is reasonable, the employer must provide such accommodation except when the accommodation would cause an undue hardship. And Kathryn, can you provide our guests with a refresher on what undue hardship is and discuss some of the considerations and concerns they may have since the pandemic?
Of course. As you probably are all aware, an accommodation poses an undue hardship if it results in a significant difficulty or expense for an employer. We take into account the nature and cost of the accommodation, the resources that are available to the employer, the operation of that employer's business. And if, in fact, the accommodation would pose an undue hardship, the employer is not required to provide that accommodation. But I will say, that's not the end of the conversation. At that point, the employer does have an obligation to consider other accommodations that may not prove to have the same undue hardship. Now, we all know that prior to the COVID-19 pandemic, most accommodations did not pose a significant expense when you considered that against an employer's overall budget and resources. There has been a bit of a shift with that, and there is consideration for loss of income stream or even the amount of discretionary funds that are available, which is a very relevant question during a global pandemic. And if this went to litigation, for example, there would be an analysis of what were those, was the income stream affected? Were there discretionary funds available? What's the expected date that the restrictions on any operations of that employer would be lifted? And with that in mind, an employer just really has to weigh the cost of a requested accommodation against its budget, and they have to take into account other constraints that are created by this global pandemic. And I always remind clients to consider low or no cost accommodations when you're involved in that interactive process that Marquetta discussed earlier. I think sometimes it's more helpful to look at practical examples than to just talk about the law. So
I agree.
Let's take an example, Marquetta, and kind of go through an analysis.
Sure.
So if we had a teacher, we'll call him Tom. Tom went to a teleworking arrangement back in March when schools closed, but his school did reopen during the fall. And he has now requested the ability to telework instead of reporting back to the physical school building. Just to give you background on Tom, he's 70 years old, and his request for this accommodation is related to his age and his opinion that any potential exposure to COVID-19 would pose a great health risk to him.
That's a common one.
It is. So as part of the interactive process that we keep mentioning, the school district and Tom sat down. They discussed the essential job functions that Tom had as a teacher. And Tom specifically asked the school district to remove one of his essential job functions, which is being physically present in the classroom to manage that classroom and to teach the students face-to-face. So Marquetta, let's talk about what should a school district do when Tom comes and requests for this essential function to be removed so that he can work remotely.
If we're following what I like to consider my kind of tried and true interactive process checklist, the first part of that analysis is going to be, does Tom have a disability in which he's seeking this accommodation for? And so I think that sometimes during the COVID pandemic, what we're doing is we're relaxing our standards. And I know that our guests have heard both you and I say interactive process a number of times, but it's so important to remember that it's almost a fail-safe for us. So we've got to start with that disability analysis, just like the court did in that Fletcher versus Giant Eagle case.
I think you're right, Marquetta. And then, employers have to be reminded that even in a global pandemic, an employer is not required to remove essential job functions. So in this case, there does need to be that interactive process with Tom to talk about his concerns. But I think what would end up happening, in my opinion, is that a school district would probably want to come up with potential accommodations that could protect Tom, that could address his concerns. That could be masks, plexiglass barriers, that could be ways
like, what is he really trying to get to?
Exactly.
What does Tom feel like he really needs? And as Kathryn stated, we're never required to remove essential job functions, even if we've done that at the height of the pandemic, because everybody was jumping right into a mode that was new. And it was not something that we had experienced before, but certainly going forward, now that we've got somewhat of our legs about ourselves and we can walk on some clear ground, what is it that Tom really is looking for? So while Tom may think that he needs removal of essential functions, it's that interactive process that's going to get the employer to determining what is it that Tom is really asking for, and is he asking for something, or is there something reasonable that can be provided to Tom to accommodate whatever that limitation is in his disability?
Right. Let's pivot though and have a similar example, but with a few changes.
Sure.
That might change the result of what this analysis would show. So let's say instead of Tom making a request, we have Jennifer. She makes the exact same request. She has been virtual and she would like to remain in a teleworking arrangement. But Jennifer's not a teacher. She works in a central office within a K-12 district, and she handles leave requests. So Jennifer submits this request for a teleworking accommodation. She bases that on the fact that she has severe asthma. She provides medical documentation that supports that diagnosis with the asthma and her concerns about exposure to COVID-19. And when the school district sits down with Jennifer, they talk about facts like all of Jennifer's meetings are still being done through a virtual platform. She's not meeting face-to-face with employees or others. But there are a few functions. For example, Jennifer's concerned because one of her jobs is to process mail, for example. So if she's not physically able to come into the central office building, that role will be limited. So in this situation, Marquetta, what would that analysis look like if you had a client call?
And this is not an easy analysis. This is one that we probably spend a lot of time with our clients on. One of the things that I'll be looking at is, where is the workplace right now? So for instance, in this central office, has everybody been ordered to return to a physical in-person workspace? What are other employees doing? What is Jennifer's main concern about wanting to continue to telework? Is it simply just she doesn't want to contract COVID, or is there something else going on? We've got to go through a very thorough analysis of that. And as you've stated, she's got some essential job functions that she was relieved of when she was on a telework capacity, but we don't have a requirement to pass on those. And if opening mail is truly an essential and not a marginal job function, then that's also a consideration that has to be made. So there's a number of weighing and balancing of her request and the circumstantial conditions in which she works in that we would have to consider.
I agree, Marquetta, and I think it's not easy sometimes to decipher whether a job function is marginal or essential, but it is a very important part of this process for an employer, because if the employer concludes that this mail opening in this simple example is a marginal job function, at that point, in my opinion, she would probably be entitled to that accommodation.
I would agree. I would agree.
I think the key here, and Marquetta said it and I've said it, it's that interactive process. It's the process of sitting down with Tom, sitting down with Jennifer, going through the fact-specific inquiry. And sometimes employees will ask for certain accommodations, but you have to get to the heart of what they really need. Are they really, is what they really need to be home, or do they really just need some protection, some level of protection from exposure? And there are many, many ways that you can accommodate that. So a lot of times it requires a bit of creativity on the part of an employer.
It does, definitely creativity and definitely flexibility. Well, Kathryn, you make a great segue into a topic that we must cover, which is telework. All of your examples dealt with telework requests because those are probably the bulk of the accommodation requests that we're seeing during the COVID pandemic. And so it's now well known that certain disabilities do place individuals at a heightened risk of serious illness or death from COVID. And because of this, employees who suffer from one or more of these disabilities may need to request an accommodation to protect themselves from exposure. While this is not an exhaustive list, a reasonable accommodation could include telework. It could include any other type of modified work arrangement or a temporary transfer to a different position. So we have a number of things that we consider, but I'd like to stick with telework. So telework or remote work has been the most common. And we can think about for most of the year since the World Health Organization declared COVID-19 a pandemic, that we have had uncertainty with how requests for telework might be viewed after the pandemic is contained or after reopening, as we've just discussed with some of Kathryn's examples, and the requirement for employees to return to workspaces. Primarily because BC, telework was often frowned upon. Employers found reasons to deny telework, rightfully so, and it just wasn't a reasonable request. However, then the entire world began to telework, and suddenly it became very doable. It was necessary, and a lot of the world is still teleworking. And then we started to pull the Band-Aid off and reinstitute requirements for employees to report in person, or we're certainly making plans to do that right now. But because we have successfully teleworked or worked remotely in the past, our requests did not, and they have not stopped. So in summary, one of the things that should provide employers with a bright light in this tunnel is that the EEOC has clarified that a temporary shift to a telework environment during the COVID-19 pandemic does not force the employer to accept all telework requests in the future. Also, it's determined that determining whether a telework arrangement makes sense remains a heavily fact-specific inquiry, which means you can still rely on your requirements under that interactive process. Finally, employees should be mindful that when evaluating accommodation requests, they should continue to participate in the interactive process as required. So again, in some of the scenarios that we presented, telework may or may not be a reasonable accommodation after the workplace reopens. So assume that you permitted employees both in the classroom and outside of the classroom to work from home. Once your workplace reopens and all staff is recalled, you don't automatically have to grant telework as a reasonable accommodation to every individual with a disability who requests it. And employees are slow to pick up on that, but understand we do have that guidance. Rather, anytime an employee requests an accommodation, you are entitled, as we discussed in these examples, to understand the disability-related limitations that necessitate that request. And if there is no limitation that requires telework, you don't have to provide it as an accommodation. Kathryn, do you want to add anything to that?
No, I think those are all great points. And I do think there's a lot of freedom in the fact that we do have that guidance, that this is just because we've made it work in the past does not mean that we have to continue to make it work, because to be honest, some of those essential job functions could not be performed back in March, April, May, when everyone was forced to be home. And so there are very real situations that employers face where they need employees to be physically present. We see that certainly in K-12, also with our higher ed clients. So this really does have to be a factually specific analysis. And a lot of times those are the types of analysis that we will be very heavily involved with our clients in, helping them navigate, because what we don't want to see is down the line the litigation that can come when there's not a proper analysis done.
I agree. And you touched on a very important point. The fact that we may have temporarily excluded or excused the performance of one or more essential functions that we truly determined to be essential does not mean that we have to continue doing that. There were some different circumstances when our workplaces were closed and everybody was teleworking. But again, telework does not always present a feasible option. We don't have to permanently change an employee's essential functions, and it may or may not pose an undue hardship. It's just required of that factually specific analysis. Now, the other thing that is something that we haven't talked about a lot is when everybody was teleworking, we didn't do any kind of analysis of whether people were capable or had the right equipment or if their jobs were suited for telework. One of the things that we can look at now as we go into, or now and post-COVID pandemic, is that telework experience may be important for certain accommodation requests. So if we're going through our regular interactive process analysis, suppose before the pandemic, an employee with a disability asked for telework as a reasonable accommodation and showed a disability-related need for it, not simply fear of contracting COVID, but we denied it because of concerns about whether she or he could perform the essential functions remotely. If they gained some temporary telework experience during the crisis, it could be relevant to consider during a renewed accommodation request. So we don't want to rely on old analysis when we get new requests from the same employees. Would you agree with that, Kathryn?
I absolutely would. And you know, a lot of our clients have made shifts to have more technology available, more there was a lot of things that had to be done back in March to allow people to continue working from home when everything was shut down. And that's going to be relevant moving forward because there's sort of this proven ground that, okay, we could make it work. And so we can't get, you know, a year from now and just start stamping denial on these requests when we sort of almost had a proof in this experience that in some situations, a teleworking experience can work and can function.
I agree. And speaking of the stamp denials that we don't want to do, even with this EEOC guidance, I think we would both caution you that you don't want to heavily rely and put all of your eggs in the basket under an undue hardship defense. We certainly anticipate that employees that will bring claims related to failure to accommodate and discrimination based on disability will try to present evidence that employees in the same or similar positions effectively and successfully teleworked during the pandemic.
Totally agree, Marquetta.
You know, there's some very early 2003 EEOC guidance that we don't really talk about. It's a telework fact sheet. And employers tend to not pay attention to it, but there are a summary of facts that the EEOC suggested that employees consider when they're looking at telework. And one of them is the employer's ability to supervise the employee away from the workplace, whether any of those duties require the use of certain equipment or tools that cannot be replicated at home, whether there's a need for face-to-face interaction and coordination of work with other employees, whether in-person interaction with outside colleagues, clients, or customers is necessary, whether the position in question requires the employee to have immediate access to documents, other information located only in the workplace. And I think that guidance is still relevant today.
I agree. And looking at, you know, just looking at those different factors when you are presented with a request for this accommodation, I think would go a long way.
Absolutely.
In providing some protection to you as an employer.
And I guess the last thing I'll add on telework is if you're in a position and your employees are still teleworking, take this opportunity to evaluate the effectiveness of telework. Take this opportunity to really look at if this is something that can go into the future. Has it been successful? And it won't be a one-size-fits-all policy or evaluation across the board. And I think this is a great segue, Kathryn, into discussing performance evaluations of employees in this remote or virtual environment.
I was just about to say the same thing, Marquetta. You know, as we're living in a world where a lot of you may still have a lot of virtual employees, you may still have employees working from home, it raises a lot of questions about performance management. Now, I'm sure that, you know, I mean, in many states, a lot of the performance reporting requirements have been waived. So in Georgia, for example, for K-12 institutions, a lot of the TEKS, leaks, all those reporting requirements have been waived. But when we're now 7-8 months into the pandemic, it becomes obvious to employers that we can't just indefinitely suspend the management of our employees. And so the question becomes, how do we effectively manage our employees during a global pandemic when some of them may not even be coming into a physical workspace. One thing that we've noticed in our practice is there's a temptation, I believe, to try to put a lot of parameters around virtual work arrangements, which is understandable, but we want to caution you because there can be some problems with that. When you're creating more stringent requirements for virtual employees than those who are reporting to a physical building, you have to consider what the impact of that is.
Yes.
So if we take, I think examples are helpful. If we had an older employee who's right now teleworking because that individual is at a high risk if exposed to COVID, if we then go to that employee and impose a bunch of restrictions on how they're supposed to operate, how they're supposed to do their job, and increase the amount of, what they have to report to their supervisor, things like that, that could be viewed and very possibly would be viewed as age discrimination. What are your thoughts, Marquetta?
I would agree.
I think another minefield is trying to handle performance expectations for employees who are utilizing intermittent leave. So obviously intermittent leave, that's not a new concept, but what we're seeing in our practice is that intermittent leave is becoming more and more common, and which we're going to address later, the FFCRA, Families First Coronavirus Response Act. But there have been employees who have had to take leave opportunities because their child's daycare or school has been closed, or they're caring for an elderly person who, there all the different things that we will discuss later in this presentation. But when we're looking at someone who's on any sort of leave, intermittent or otherwise, we know that there are duties that may be missed for that individual. And what I want to touch on is the importance of being clear and upfront in your communication with the employee about the expectation. So things like, is the employee still expected to complete certain tasks, or is the school or university going to provide any flexibility in that? So if let's say we had,
would those tasks be passed on to someone else?
Exactly. If we had an employee, let's say at a university level, who needed to take intermittent leave from 1 to 3 o'clock in the afternoon because their child's school is closed and they need to attend to that child, but the same employee's been directed that they're supposed to submit certain reports to their supervisor by 2:30 each day or once a week. If there's not a lot of clear communication up front about whether they're still expected to perform that duty, or what modifications might be made regarding timing for the submission of those required reports, then you might run into an issue where that employee fails to meet the expectation, and then you're disciplining an employee potentially because they were on intermittent leave. And
that's correct.
And because you weren't clear up front about their responsibility and duties.
And then we run the risk of both interference and retaliation claims under the FFCRA. The other thing that I'll add there is that because of the notice requirements that are much less related to FFCRA leave, much less than we would anticipate with traditional intermittent leave under the traditional FMLA, one of the things that happens is we are now granting leave because we have to, right? We don't have to go through this analysis. The federal government says this is the leave. But it has the same impact that it may have had if the request had come in as a traditional intermittent leave request under the traditional FMLA or under the ADA. And so what happens there with traditional FMLA, we often advise the employees to try to take their leave if they could as practicable so that it was not unduly interfere with the employer's business. The other thing is we may have a similar situation. I'll give an example, such as an ADA accommodation request where somebody may need to leave every day from 2 to 4, which ends their workday for dialysis or something like that, in which we traditionally would have said that's an undue hardship. What the leave related to the FFCRA has shown us that similar situations are granted under another law. So now when we're considering non-COVID requests that look very similar, smell and walk very similar, we have to take more time to go through the interactive process instead of quickly stamping the denial. And what I'll do before we go on, we do have one question, if I can address that. And the question is, for tenured faculty, Could you add as an essential job function in-person teaching as opposed to virtual teaching? Kathryn, what do you think about that?
I think that there has to be more analysis there. So we have to look at why is that an essential job function? Is it that the task, the teaching cannot be done virtually? Is there another reason that it must be face to face? I think we would need to really have a careful analysis. I could foresee a factual situation where it is important to have face-to-face instruction, but I don't know that would uniformly apply across the board.
I would agree with you. There are a couple of things, as you stated, this really does require some careful analysis. One of the things that we'd be looking at as well with that is, what is the difference that the university or the institution of higher education makes related to tenured and untenured teachers as to why that in-person requirement is different? Is there something that's a different duty? Some of our case law before COVID showed us that courts really did defer heavily to employer concerns about being in person or working remotely, and really placed substantial weight on what employers said was an individual or an essential job function. As Kathryn stated, that may not apply right now so uniformly across the board. And so we really have to do some careful analysis there.
Agreed. Moving on to another area of performance management that I think is particularly relevant to many of you would be, how do we handle absences? So if we have an employee who has just been missing in action for 5 days, is it appropriate or legally permissible for the employer to approach that employee and ask why they've been absent? And the answer to that would be that an employer can always ask why an employee has not been reporting to work. That's not a disability related inquiry. It's not a problem. So there's always an ability to ask those questions, but I do think that there are some practical issues when you have a workforce that is remote with just basically keeping track of absences and having policies, that can adapt to these new times.
I would agree. And as you emphasized earlier, we don't want to create a scenario where we're creating a disparate impact situation. Most of our employees that may be working from home are of a certain age. They have a certain disability, they have a certain condition, or maybe they're pregnant. And so we don't want to create a situation where we are unreasonably scrutinizing or putting more severe performance management concerns because someone is at home and missing those same concerns or performance management practices for employees that are inside of a physical workspace.
I agree. Before we go to our next topic, I do want to give a code word. We are applying for CLE credit for those of you in Georgia, and you will need this when you complete the survey at the end, which will send you that link. But this will be our first code word, and it's Nelson, N-E-L-S-O-N. So just make a note of that, and we'll be sending a link later where you'll be able to put that in. And we'll give one more code word at the end of today's presentation. But without anything more about that, Marquetta, I think we also wanted to just touch on the FFCRA and provide a little guidance on that topic as well.
Sure. There is so much guidance about the FFCRA that we won't rehash what those reasons are, particularly since that is set to sunset December 31st, 2020. But what we will remind you is that there is certainly a best practice in being consistent in the review and application of that law regarding paid leave, which means if you've got several people across your institution that are administering or receiving those requests, then you also would like to need to have some checks and balances to monitor to make sure you have some consistent decisions. We certainly anticipate that when employees start to settle down and may file lawsuits, that we will get some interference and retaliation claims. And it may be problematic for employers if we have certain supervisors that have administered leave in different ways. And traditionally, we may have supervisors and managers administering or approving requests for leave that have not been trained on what's necessary under these types of laws, the questions to ask. A lot of this depends on, are we asking the right questions? Are we gathering the right information? We do have forms that are available And hopefully employers are using those to make sure that we're gathering just the right information, not too much information and not too little, to make sure that we are appropriately applying this leave. One of the other things that I will add is that make sure we have the documentation, because this is not the employer's money. This is federal money. And so if for some reason there is an audit of the requirements and the leaves that were granted, we want to have the right documentation. And the last thing that I will add there is, considering that we're at the end of the year, if you have not done this, I would certainly emphasize some training. Even if you don't have various managers and supervisors that are administering this type of leave or receiving information or making decisions, but that they know how to respond to or where to escalate requests for these types of leave. And I think Kathryn will talk a bit about what happens. Are we looking at whether this FFCRA will be extended past December 31st, 2020?
Well, it's a great point, Marquetta, and all the more reason to really look at your training and look back on how this has gone, because I think everyone expects that there may be an extension of the relief from the FFCRA. There's been a lot of, I'm sure you all are aware, there's been a lot of different stimulus legislation that's been proposed.
Yes.
But I mean, what's clear is that any of these stimulus packages that we're looking at are likely to include an extension of some of these benefits from the FFCRA and these paid leave provisions. And so because, the FFCRA enjoyed such widespread support in the legislature, and because there is so much pressure and talks about new legislation, new stimulus legislation, we expect that there will be further requirements, even after the FFCRA sunsets at the end of this year,
yes,
that you're going to need to implement, and honestly implement it quickly. So the more that you can wrap your mind around what worked when we were implementing the FFCRA, what didn't work, and how can we implement this better and make sure that we're really looking for a consistent response and a consistent application. Because
I would agree.
Even though the FFCRA seems straightforward, even an inquiry as simple as, okay, the child, the child of this employee's childcare is closed.
Yes.
That's not a simple analysis, as we've learned.
Yes, we have.
You have to ask a lot of probing questions to really ascertain whether that person is entitled to the leave under FFCRA. Things like, is there another adult in the home who's able to provide that child care? Is the child's school closed, or is the parent electing to keep them in a virtual model? Those are all the kind of questions that a building administrator or manager may not think to
understand
or understand. Correct.
I would agree.
I think that's a good segue to our final conversation, which is the issue of public health disclosures.
Yes.
And I think this is something that many of you are probably grappling with. And just this concept of, at times you do have a need and a requirement to report certain positive COVID results and things like that, but how much can you report? How much information can you solicit from your employees? And it can get very confusing. So even though there's not a lot of federal law that specifically puts requirements on colleges, universities, K-12 public schools to notify public health officials, that burden is legally usually put more on like the doctors and healthcare providers.
Yes.
There are some, certainly in Georgia and in other states, there's a lot of state guidance from the Department of Public Health. There's a lot of state issues where school districts are being directed to report certain information, to report positive test results, to facilitate with the Department of Public Health their ability to do contact tracing. And that requires a lot of interaction and a lot of cooperation from employers. And so I think an important thing to talk about is how much information do you want to solicit, and can you solicit from your employees? So for example, during a pandemic, you as an employer can certainly ask your employee if they're experiencing symptoms of that pandemic virus. So in the case of COVID-19, that might include asking questions about whether they're experiencing fever or chills or sore throat, cough, and shortness of breath. So that information can certainly be solicited from your employees, but once you have that information, there's certainly a duty to maintain confidentiality of that information, and even to store that information as a separate medical record, not part of that employee's personnel file.
That's very important.
Yeah.
I think one of the things that we haven't touched on, and as you're talking about the questions that we ask, is also how do we ask those questions? For instance, we can't ask employees whether they have been exposed to COVID-19 by a family member, by a son or daughter, or by a mother or father. We can ask them, have they been exposed to anyone who's tested positive for COVID? Because if we ask questions that implicate family members, we also may implicate the anti-discrimination requirements of the Genetic Information Non-Discrimination Act, Gina.
That's a great point. Another, and I touched on this a moment ago, but a real concern for employers is how do we store this confidential medical information? You know, you may be doing a daily temperature check of employees. You may be constantly obtaining very confidential and sensitive medical information regarding your employees. And what do you do with that? Particularly if some of your management and supervisor level folks are working remotely, because that adds another layer of how do we maintain this as a confidential medical record.
Right.
So I think it's very important to look at your policies, make sure that they still, that they, you know, even in a pandemic, that they're still going to give you that protection, because you want to make sure you have policies in place that will protect that employee's medical information, their identity, shouldn't be released to people who don't have a need to know that information. And you know, if your management or if a lot of your employees are still working remotely, you really have to look at how are they going to safeguard this information, and do you have policies in place where, you know, their laptops, they understand that when they're working from home, their laptops should be stored in a way and should be left in a way that others in their household wouldn't be able to obtain that confidential information.
Right. In my opinion, I think we will be navigating employee privacy issues for some time, well past the COVID-19 pandemic. And I think, as you stated, in some cases with employers with disjointed departments and schools and many people to receive medical information, employees working from home, this is an issue that we are anticipating that we may see in certain litigation. And in some ways, COVID has caused employers to relax those traditional and best practices around employee privacy, medical testing, asking questions, even just in the theme of being empathetic to our workforce. We work very closely with people in schools and higher education institutions. They become family like us. And so sometimes that need to be empathetic and receive information, we may be crossing the boundaries of what may be legal. So we must still have a constant balancing act of gathering information, gathering enough, as Kathryn stated, but not more than necessary, and still finding that balance to protect employee privacy and confidentiality as we continue to navigate during what remains an unprecedented time.
Agreed. A couple more just quick notes on that topic, and then I know we're getting close to the end of our time, but you know, the ADA is not going to interfere with your ability to have a designated representative in your organization who will be able to go interview someone who potentially has a positive COVID result. Right. And that's certainly important. We understand there's very practical reasons that you as an employer want to obtain that information and to be able to do the proper contact tracing and to work with your Department of Public Health so that you don't have just a mass outbreak of the coronavirus within your workplace. But there's some very real concerns, because you want to make sure that your employees, anyone who's administering that, understands that that employee who's tested positive, their identity shouldn't be revealed. Any sort of communication to other employees needs to be very generic. Something like an employee on the 4th floor tested positive for COVID and you may have been exposed. And with some of our clients, they're small enough, or that particular school building is small enough that everyone sort of can figure out the identity of the person fairly quickly. But it's still important as the employer that you maintain that confidentiality, even if everyone can look around and say, well, John is the only person that's, fits that bill.
But we certainly don't have to confirm or ratify that.
Exactly. Absolutely. And similarly, we shouldn't confirm if an employee self-quarantines because of a coronavirus exposure, obviously you would have to communicate with that employee's supervisors and team that they are going to be teleworking, but you should not be communicating the reason for that teleworking arrangement.
And I think that's where that empathy crossing the boundaries comes in.
I agree. Finally, it's a consideration when you're hiring and doing onboarding, because there are some restrictions and some guidance about how and when you can ask questions about COVID exposure. So if you are screening job applicants, you can only make that sort of question, screen them for COVID, that is, after you've made a conditional job offer, not before. So there's just some very little, just things you want to make sure that you're getting right so that you don't open yourself up to a potential legal problem down the road when you're just trying your best to, implement and protect all your employees.
I would agree. And considering our time, I'd like to just throw out a hypothetical for you all to think about, and we will try to answer it for you in about a minute of what we can. But let's just start with a generalized fear of contracting COVID. We have talked about that throughout this webinar, and that is probably a very large portion of the number of accommodation requests that you're seeing, particularly related to telework and all types of workplace modifications. So I'll give you the hypothetical. The employee's name is Pam, and for all purposes, Pam is a well employee. She is looking for leave options because she's afraid of being exposed to COVID. She has children at home that she does not want to get sick. They seem to be well and healthy as well. And she would also like to have regular visits with her elderly parents, and Pam is not a caregiver for those parents. In summary, she just does not want to come to work because she thinks it's a hotbed for COVID. And because this is a 2020 hypothetical, Pam is 65, she's pregnant, and she has diabetes. But again, for all purposes, she's a well employee. Kathryn, must we allow Pam to telework?
Obviously, there is no requirement that we allow Pam to telework. I do think this is an issue that's going to keep coming up, is just this generalized fear, and we have to, really look at, and it's similar to the case that you mentioned earlier, just generalized not wanting to wear a mask, but no link. I think what we're seeing is we're looking for that link, and when there's no link to medical documentation or rationale or reasons for why, reporting to work would be a problem for their health related to their disability, that's a problem.
Absolutely. And this is certainly, even though Kathryn has aptly covered a number of things in this short time, this is certainly one that we would take more time than 3 minutes on, because, we first look at whether Pam has any eligibility for paid leave under the FFCRA. And as Kathryn has stated, we didn't hear anything just in that fact-based scenario of a generalized fear of COVID and what Pam has presented to the employer as her need for leave. But we also should consider state and federal disability laws. Pam has a disability, but are there some limitations that require her to telework? What we know is that she has a health condition, but she's told us that she's well and she could work. She doesn't care for a family member. She's not caring for her children because of a COVID-related reason. But as Kathryn discussed earlier, this is also a time for employers to be creative and to be flexible as we try to balance the need for empathy with our employee workforce and to have efficient operations. We want our employees to be available to work. And so the other thing that we might need to consider is if there are some employer policy related paid leave options for Pam, or unpaid leave options, where she could still get the benefit of taking leave as she believes that it's necessary for her to do. Otherwise, Kathryn, might we potentially get to a place where we have to discipline Pam if she refuses to come to work and we find that there are no options available for her to take leave?
I think that could be the unfortunate answer when we go. We would need to certainly analyze all the different things that you've mentioned, but there are certainly going to be, probably for each of you, there will probably be situations where you have an employee who it's just a refusal to come to work situation. And while you empathize with someone who has that much anxiety about contracting COVID-19, the situation with Pam may very well be once you kind of exhaust all this different analysis, you may come to a point where you're having to issue a directive to come back to work. And then if that directive's not, if she doesn't comply with that directive,
Right,
you
it's
may
not
be
enough.
disciplining Pam. I mean, you may even end up with a termination situation,
Right.
which really pulls at the heartstrings. But, we have to implement all of these different things. We have to be consistent with our application.
Right.
And we have to make sure that, we're not just granting paid leave under FFCRA to an employee who doesn't meet those requirements.
Absolutely. I think what this scenario and others has shown us is that COVID-19 just doesn't fit neatly within the framework of our existing laws and what we know about leaves and accommodations. However, we've given you some best practices. One, consistent application, training of those persons that are reviewing and receiving these requests for leave, and follow that interactive process. Follow what you know about what the ADA required of you for the interactive process prior to the COVID pandemic. And while all of you are taking very different approaches with respect to school reopening, university campuses reopening, your plans have included full-time virtual, remote learning, in-person, hybrid models. There are some things that you will have to continue to consider. For instance, there's a lot of discussion on vaccines. And you're probably sitting right now with your task force figuring out, will we require employees to take vaccines? Will we require employees to continue to wear a mask? Will we require COVID testing or other medical examinations under the ADA? And Kathryn, I think we could definitely help our guests figure out and work through some of those things as they continue to navigate this complex time.
I agree, Marquetta. And a lot of times that careful analysis up front will save you so much expense and time down the road when you can prevent some of this litigation that will follow if you're not able to step back and take a very careful and measured approach and seek counsel when needed. Because as you've seen today, some of these topics that may seem straightforward, really, Marquetta and I will bounce ideas off each other
Absolutely.
for an hour about, one accommodation. So it can,
Yes.
So this can definitely, I think we would all be wise to take the time to do this sort of analysis up front. I think it will only benefit you in the long run.
I agree. And with that, we thank you all for joining us here today. And remember, we are here to help you navigate through your employment law concerns related to COVID or your general employee workplace concerns unrelated to COVID.
And the final thing I'll add is the final keyword for today's webinar is going to be Mullins, M-U-L-L-I-N-S. So please just make a note. So we have Mullins, M-U-L-L-I-N-S. You will receive an email after today's webinar that will have a link, particularly if you're in Georgia, we have applied for CLE credit. And so you'll just need to fill that out and provide the keywords that we told you today. But we really appreciate your time and the opportunity to speak with you and hope that we can help you down the road if any questions arise in the employment law context.
Thank you all.
Thank you.